A 3-year process to amend the Constitution has been stopped by a majority decision of 7 Court of Appeal judges, shocking a section of the political class that had appeared bullish regarding the process. After 4 days of hearings before the court and 7 weeks of deliberation, the judges upheld the verdict of the lower court and issued a permanent injunction barring the IEBC from conducting a referendum on the Constitution Amendment Bill 2020. Legal experts are now divided on the way forward for proponents of the BBI.
That's hard to say now what will happen to the BBI process, given that both the High Court and the Court of Appeal are fairly unanimous on its unconstitutionality. So that's going to be a bit of a challenge.
The proponents of BBI believed in what they told us, that BBI was meant for the good of this country. Then they should take what is good in that document and which doesn't require a referendum and go ahead and then legislate it for the benefit of the people. The 5% development levy in the wards does not require a referendum. Let them go ahead and implement it. The 35% devolution kitty does not require a referendum.
As parties await certified copies of the ruling so as to decide whether to file an appeal or not, there is consensus that an appeal before the Supreme Court could be completed within the next 3 months. But its implications politically is a different matter altogether.
Moving to the Supreme Court would be a tall order. It will be a tall order because if you look at the decision of the Court of Appeal, they have in principle upheld 3/4 of the judgment of the High Court. And if you go to the specifics, which were actually the main bread and butter for the proponents, the decision of the High Court has actually been upheld.
And whilst the court gave its verdict, the National Assembly recently seemed to give some of the BBI proposals a fresh lease of life, inviting Kenyans to prepare to submit their views in writing on the Constitution of Kenya Amendment Bill 2020. The memoranda is then expected to be submitted to the Constitutional Implementation Oversight Committee thereafter.
What had they called them to do? To submit their views on Constitutional Amendment Bill of 2020?
Yes.
The same one that has just been struck out?
Yes.
It is moot. It is dead as a dodo.
In the absence of a referendum bill, the Court of Appeal today gave the clearest directions yet on what would need to be done to implement a successful amendment of the Constitution by popular initiative.
Whoever is proposing amendments by way of popular initiative must make sure that it is initiated by the people, that it is controlled by the people, and does not involve in terms of its promotion, that it does not involve the executive. That I think, and that it is participatory.
That we must remain true to the spirit of the Constitution. There is the last institution standing, and that is the judiciary. That despite the chaos that they have been taken through, they are able to stand on their hind feet and say, this is right and this is wrong.
The 7-judge bench raising the bar on amending the Constitution through popular initiative and making it even harder to amend the country's supreme law. Wahiga Mwaura, Citizen TV.